hundreds of innocent people wrongly accused, their lives destroyed. Why? Because a computer said they were guilty. The post office used flawed computer data to prosecute its own workers. Privately, no independent check, no external oversight. The law allowed it. Today, the law treats computer outputs as reliable, even when they are wrong. And private prosecutors, they don't need to prove they are impartial. What's wrong with the law? Call for evidence ends 15th of April and 8th of May respectively. Every voice shapes the future. Get involved in this call for evidence. Full details are linked below. The law failed them, but your voice can help fix it. Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In our last news session, we highlighted the government's call for evidence on two key issues in the criminal justice system: the use of computer evidence and private prosecutions. Today's video is the first in a two-part series in which we will focus on the call for evidence concerning computer evidence. We will turn our attention to private prosecutions in next week's video. Before we dive in, I want to take a moment to sincerely thank you for your continued support. We're truly feeling the love as more of you reach out, share your thoughts, and engage with our content. It means the world to us. That said, 72.8% of our viewers still haven't subscribed. If that's you, we would love you to join our growing community. Subscribing is completely free, but it makes a huge difference for us. It helps us reach more people, keep the conversation going, and continue creating content that matters. Our mission is to humanize the criminal justice system, to shift it from being about rules to being truly about people. If that resonates with you, we hope it's reason enough to hit that subscribe button below and be part of the change. Thank you. Let's dive into this important issue, the use of computer evidence. A call for evidence was launched by Sarah Sackman, KCMP, Minister for Courts and Legal Services, on the 21st of January 2025. Submissions are open until Tuesday, the 15th of April. We hope this video gives you invaluable context and perhaps encourages you to get involved and have your say. In our introduction, we asked, what's wrong with the law? Let's start with the basics, as we always do. Prior to 2000, the reliability of the computer needed to be proved before computer evidence could be allowed. This was encapsulated in Section 69 of the Police and Criminal Evidence Act 1984, which stated that in any proceedings, a statement in a document produced by a computer shall not be admissible as evidence of any fact stating therein, unless it is shown that there are no reasonable grounds for believing that the statement is inaccurate because of improper use of the computer, that at all material times the computer was operating properly, or if not, that any respect in which it was not operating properly or was out of operation was not such as to affect the production of the document or the accuracy of its contents. This provision was, however, repealed by Section 60 of the Youth, Just and Criminal Evidence Act 1999 and replaced with a rebuttable common law presumption. That is a legal presumption, though technically rebuttable, that any electronic device is functioning correctly. In simple terms, the default assumption is that the computer or system is reliable. While this presumption, as we say, is rebuttable, i.e. can be challenged in theory, in practice it's often extremely difficult to do, especially for defendants. That's because the very evidence needed to question the reliability of the system is usually controlled by the prosecution or another powerful party. This flaw became painfully evident in the post office scandal. Sub-postmasters were expected to prove that the Horizon computer system was unreliable, yet the critical logs and technical data they needed were held by Fujitsu, an organization effectively under the control of the post office, which was also their prosecutor. In other words, they had to depend on the very part accusing them to provide evidence that could weaken the case. It's a striking example of the systemic failure in how computer evidence is currently handled under the law.
The question is, why did the courts routinely fail to recognise that the evidence before the court that was being put forward by the post office was incomplete and unreliable? Why did that happen? That's a massively important question that needs to be addressed. And it really comes full circle to where we started. Computer evidence is on the whole poorly understood by the judiciary.
There was Paul Marshall, a barrister who represented several prominent post office victims in the Court of Appeal, including Tracy Felsted and Seema Misra. He played a pivotal role in bringing to light that now infamous 2013 Clark advice. At a time when public outrage was directed almost exclusively at the post office, Paul Marshall stood out as one of the few voices boldly criticizing the role of the courts. He argued that the judiciary had allowed itself to be misled or even manipulated by the post office, highlighting a deeper systemic failure. His critique went beyond condemning the action of the post office. It called into question the wider legal framework that allowed such miscarriages of justice to happen, particularly the court's failure to scrutinize the reliability of the computer evidence presented before them. In August 2020, the then Parliamentary Under Secretary of State Alex Chalk invited Paul Marshall to submit a paper on proposed recommendations for improving the existing approach under rules of court for the disclosure in court proceedings of computer-derived evidence. Recommendations came in the form of disclosure. He suggested that the disclosure should undergo 2 stages. During stage 1, the party who wishes to rely on a document produced by a computer must disclose any known bugs, error logs, release change logs, and actions taken. Information security standards, including access controls, vulnerability and patches, system audits and management records to verify adherence to proper standards, and reliable records of error reports and system changes, including safeguards like digital signatures. The disclosure must be carried out by someone authorized and knowledgeable. It must require a reasonable and proportional search for relevant documents, and evidence must show that the records are genuine and relevant, and that access to system data is properly controlled to prevent tampering. The recommendations added the parties must collaborate and the process should not have an adversarial approach. Disclosed data should be in a usable format, and the party who challenges the evidence must not be required to pinpoint specific flaws to trigger the disclosure. Properly managed bespoke systems should have these records readily available, and missing records may indicate poor system quality. At the end of stage 1, if stage 1 reveals a high number of defects suggesting unreliability, specific failures tied to the evidence in question, or inability to show proper control over the system or data, then stage 2 is triggered, whereby the party relying on the computer evidence must prove these issues don't undermine the reliability of the material. The paper also highlighted the context in principle that all large systems have bugs, even reliable ones. The existence of bugs doesn't automatically discredit a system, but courts must still consider how these might affect the evidence. Evidence of reliability is not the same as proof of infallibility. However, in May 2022, Conservative MP and Parliamentary Under Secretary of State for Justice James Cartledge said, "We have no plans to review the presumption as it has wide application and is rebuttable if there is evidence to the contrary." Given what we have discussed, Cartledge's statement comes across as rather naive. As we have already seen, confronting this assumption in practice is far more complex than it initially seems. The matter has now thankfully resurfaced with the new government launching this call for evidence. So let's look at this call for evidence. The first point to note is the scope. The government wishes to limit the scope of the reform to include only accounting programs such as the Horizon system used by the Post Office, automated fraud or plagiarism detection software, automated reporting based on records entered into devices, such as handheld devices for entering patient interactions in a hospital. However, the government suggests that evidence merely captured or recorded by a device should be excluded. For example, digital communications between people such as text messages, messages sent through web-based messaging services, social media posts, emails, or digital photographs and video footage, breathalyzer readouts, mobile phone extraction reports. This exclusion is, in our view, deeply problematic, as these forms of digital evidence are routinely central to serious criminal cases, including rape and sexual assault, for example, messages or photos used as evidence of consent or coercion, hate crime and online abuse, terrorism and incitement to violence, domestic abuse and stalking. Digital evidence is often treated as inherently trustworthy, yet in reality, metadata, for example, timestamps, location tags, can be altered or spoofed. Photographs and videos can be manipulated or deepfaked. Mobile data extraction tools can produce partial or inaccurate records and may be misunderstood in court. It is, in our view, inconsistent and illogical to apply enhanced scrutiny to accounting or system-generated data while exempting digital communications and media. If anything, the latter is more prone to manipulation and misinterpretation and often more contested in court. presuming the reliability of such evidence without scrutiny of how it was generated, stored, or accessed creates a dangerous risk of injustice. It invites courts to treat digital outputs as neutral facts when they may in fact be flawed, corrupted, or intentionally altered. We strongly urge the government to extend the scope of the proposed reform to include all types of computer-generated or computer-mediated evidence, not just those involving accounting or automation. We also urge the government to require courts to assess the reliability of digital evidence, not assume it, introduce clear standards for disclosure, including the technical context and chain of custody of digital data. And finally, provide training for judges and legal professionals on the interpretation and limitations of digital evidence. And what are your thoughts? Do you share our concerns? Let me know in the comments below. We hope that this background information provided has equipped you with the knowledge to take the initiative and respond to this call for evidence. I especially urge those with IT expertise who are better informed on this issue than we are to help persuade the government to broaden the scope of this reform. Without such an expansion, it feels like a significant oversight and a missed opportunity. If we have sparked enough interest and you'd like to get involved, the government is inviting participants to complete a questionnaire linked below and send their responses to computer.evidence@justice.gov.uk. In a digital age, reforming the way computer evidence is treated is not optional, it is essential. But reform must be holistic. To exclude key categories of evidence risks creating a false sense of reliability and a dangerous imbalance in how justice is delivered. That wraps up today's video. As always, don't forget to like, subscribe, and most importantly, share your thoughts in the comments below. Join us again as we sit and rise in this unique trial.